Hello, hello, hello. It's Attorney Mike Gravel coming to you from Chicago as usual. And that's right. It's late night naughty court time. This one apparently made the rounds, but and a bunch of people sent it to me. I have not seen it. I've heard descriptions of it, and it sounds like it's tailor-made for Let's Talk with Mike. It really does. It really does. However, Lucificent's Lair. Big shout out to Lucificent's Lair. Link in the description to her channel. She hooks me up with a workable copy of this thing. So let's do it, shall we? Well, let me see what I got here. Let's do this.
Okay, so the state of Michigan versus Michael Hensman, case number 22-00207.
Wait, Deputy for the people.
And good morning, Your Honor. Robin McCoy, P63057, on behalf of Mr. Michael Hensman, who is appearing via Zoom.
Good morning, Ms. McCoy. Mr. Hensman, please unmute and state your name, sir.
Michael Hensman, good morning.
Good morning, sir. All right, we're here on
Where is
the
he?
defense's motion to admit prior bad acts and
Oh, there he is.
I don't see the response here from the people.
You don't have it, Your Honor. Unfortunately, I appreciate. Thank you for Ms. McCoy. Yes, go ahead.
Motion. I'm sorry. I read that wrong. That was a response to the prosecutor's motion. But yes, go ahead, Ms. McDuffie.
So yes, you do not have the response from the prosecutor. Thank you to Ms. McCoy. She did submit that information, I think exactly a week ago, almost around this exact time, actually last Tuesday. At some point I just hit max capacity, and I think that was true for me. I have my two drafts of this, but I just couldn't finish them to provide a written response in time for today's hearing. So I can respond orally to some extent, but I just couldn't get it done. So my apologies to the court and Ms. McCoy.
All right. Ms. McCoy, why don't you go ahead and make your arguments?
Okay, Your Honor, I'll start. So I filed the motion and the response to the prosecution's notice about the domestic violence testimony. So as far as the motion, we are seeking to admit evidence about incidents that occurred. There's an incident that occurred on January 25th, February 3rd, February 7th. There's a text February 11th. There's a PPO that was filed March 8th. And then there was an email that was May 1st. So I'm going to go through each item. The first being January 25th. It's my understanding that the complainant got into a car accident with the boys in the car, and that she was intoxicated. And we are seeking to admit that evidence. In this case, the case before the court, the allegations are that my client slapped the complainant, leaving a mark on her face and damaging her eardrum. And so we are seeking to admit the evidence about the car accident as a possible source of her injuries. That's the first issue, or the first incident. February 3rd, there was a situation where the complainant entered my client's home without permission, found him there with Rachel and Cookie, and basically stated to my client and Miss Lynn Cookie that if he continued to see Miss Lynn Cookie, he wouldn't be able to see his boys. And so we are wanting to admit that evidence as her 404B evidence as part of her motive to lie about what happened on the incident that happened on the 25th.
I don't know what's going on, but Rachel and Kooky already sounds promising.
Then there's an altercation on February 7th where the complainant again comes into my client's residence without permission. And my client and Miss Lynn Cookie are in the bed naked, and they said the complainant threw a vibrator at Rachel, the other woman, and that the complainant was kicking him.
There's no vibrator throwing. We're gonna just have to add to the list of rules around here.
Scratching and punching my client to get to Rachel. and that, let's see, that Leslie slapped him, kicked and scratched him, grabbed and twisted the inside of his thigh, and basically said something about you choose Rachel or me. He said he chooses Rachel. The allegations are that the complainant was intoxicated, and that let's see, that she took her jacket to hit Rachel's face, got her hand free, grabbed Rachel's hair, and then Rachel took a thumb and tried to gouge her eye out.
Exciting and new.
You know
And
it's gonna happen.
then that Rachel was on top of Leslie, that she thought Leslie had a weapon. They were on the ground, that Rachel was choking Leslie out, and that Michael told Rachel to stop. So that February 7th incident is also a potential source. We're seeking to admit that as evidence of a potential source of the injuries. First, the injuries to the complainant. Second, his reason for apprehension, what the allegations about the incident on the 25th, and I don't think neither side is debating the fact that he says that on the 25th that the complainant was aggressive towards him, and in response that he pulled a gun on himself. And so we're seeking to admit the evidence about February 7th as a basis for why he would pull the gun on. He asserts that he pulled the gun to himself to prevent her from harming him, and he asserts that when he pulled the gun to himself, she moved out of his way and he was able to leave her residence on that date. There's also the text that she sent on February 11th, basically saying that if he continued to see Rachel, he wouldn't be able to see his boys. That again goes to
Sure
the
did.
404B evidence of the motive to
Thank
lie.
you.
And then there is, let's see, there's the PPO that she filed on March 8th, barring him from her residence. And they previously he'd had reasonable liberal parenting time with the boys, but after she
All
filed.
right, Sandy, that might be my new thumbnail after this thing is over. I slapped together something. No, I didn't have a thumbnail. That might be my thumbnail. I like it. We'll see if it plays out.
This PPO, he was barred from the boys. There's a custody proceeding that's pending in this matter. He's actually continuing to have restricted access to his children, which he believes is part of her motivation for bringing this domestic violence action against him. And then there's the email that she sent to his father on May 1st, where she basically said that he is not to, she was saying something to the effect that he's permitted to, the grandfather's permitted to see the boys, but that Michael is, let's see, I'm looking at it.
Can I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
She says to the grandfather, you have to pick them up anytime after 4 on Friday. It's fine. Also, no contact with Michael. So those are the different incidents. I do have my response. I don't know if you want me to address that after the prosecutor responds to my motion, or did you want me to wait?
I think we should handle one at a time. So let's start with your motion first.
Come on, Judge
Ms.
Washington,
McDuffie's
wake up.
response, please.
We got a
Yes, so
throuple.
taking each one of these dates, so there's 1, 2, 3, 4, 5, 6 dates that are at issue
Airborne
with the
vibrators.
404B, things that defense is seeking to admit. So taking each one of those in turn, looking at January,
This
I'm
one,
sorry?
I thought it was 5. I think I may have.
I have
Wait.
January 25th.
Okay, you're right. You're right.
Okay.
All right.
So, so starting with January 25th. So defendant Hensman asserts that the complainant, Lucas, got into an accident with the boys in the car while she was drunk and her car was wrecked. And the purpose of bringing that up is supposed to be to show that that's a potential source of the red mark on her face and the alleged ruptured eardrum. There was nothing provided to support that. I don't know what the basis of that allegation is. There were some exhibits provided with the motion, but there were certain dates excluded, not excluded, but there was nothing included for this particular claim or incident. So I realized that, testimony is evidence, but I think there's got to be something to substantiate that claim. Setting aside, I think the likelihood that there would have been no OWI investigation, no police report, crash report, CPS handled with care, no information whatsoever. From that, I think there's got to be a threshold between the claim that an act occurred or a prior act or something versus a defense's any witness's ability to just sort of make unverified based on allegations about because ultimately that'll come down to an attempt to impugn somebody else's character. So I would ask the court to deny it for that particular date because there's just nothing there.
Okay, if you're moving on, just wait. I wanna rule on them individually.
Okay.
Your
So
Honor, may I respond to her assertion about the January 25th?
yes, I was going to ask you that. I mean, because I think the prosecutor's correct. I mean, you're making an argument that a car accident, actually, that was almost 30 days before this incident caused an injury with no proofs as to whether or not the accident had any type of situation where her face was hit or anything to show this court that somehow or another there was some part of that accident that would have caused any type of injury like this. So I don't see that. I don't see any proof of that.
Well, Your Honor, again,
That'd be kind of hard because they're both prosecutors, Jay.
I mean, we obviously, I know the court wanted to be aware of certain things would come out in trial. My client is intending to testify, and he was the eyewitness to the accident. He is a mechanic, so he actually was called by the complainant to the scene, and so he can attest to the damage. He actually repaired the damage to the vehicle as the mechanic and picked the complainant up, so he can give testimony to that effect. I don't know that the complainant would dispute that she got in an accident, and again, we're not in the middle of trial.
About whether she got in an accident, Ms. McCoy. The issue is there is no nexus between that accident and what would be an alleged injury. What injuries did she suffer in that accident?
Well, my client would be giving testimony about her getting in the
What is
accident.
that? Offer proof as to that, Ms. McCoy, is what my question is.
I know that he will be testifying that she got in an accident, she and the boys, that the car was wrecked, and that that she didn't seek medical attention. The police were not called, that he repaired the damage to the vehicle. So he can speak to the issue of what her appearance was on that day, any potential injuries to that effect. I mean, again, if we're in the middle of trial and he's testifying, then he would testify to this effect. I mean, does Your Honor want me to voir dire my client about this at this time?
You have to show this court that there is some reason why there would be a nexus between any injury to a person's face that would be relevant. And so far, you haven't proven that. So you can do that however you choose. But without that, my answer is going to be that it's excluded.
Okay, I would like to briefly call my client about this incident about the 25th.
And all I'm asking about is what injury. So if you want to call your client, you can, but so far you haven't made any offer of proof at all about whether there was an.
I know this is not going to happen, but what would I give for a big vibrator shaped bruise on her face? and then I could just retire. Because it would never get better than that.
Injury, whether he saw anything that would show this court that such an injury somehow existed. I have nothing.
I know that he has been very diligent, very much wanting to bring this situation into play. So yes, if I could just call my client, Mr. Hensman.
You want to do that, you understand she gets to question him.
He does, I know.
Your Honor, before they do that, I just don't want to.
Don't subject your client to cross-examination by Rachel McDuffie. that's my thought right now, and I haven't seen this.
Preclude anything for either party. Defense made two separate claims that these injuries could have occurred on two separate hold dates. So because the court is ruling on these one at a time, there's an allegation that her injuries could have come from this incident and from an incident on February 7th as well. So
well, I've heard enough about the February 7th to believe that it is possible it could have occurred from the February 7th. incident. They presented an offer of proof for
Okay.
me, enough of an argument as to that I
Okay.
believe that it could have occurred on that date. And obviously that's much closer to uh, the date in question here. So that presents an issue for me that would go before the jury. I'll let you argue, but from what I can hear so far, it does sound like that would come in. It's the accident that I have the problem with, and it's the same issue that you have. And if she wants to call her client, as long as he understands that this can be used against him at the time of trial as well, and whether he takes the stand or not, because the reality is he's making a statement at this point that can be used against him.
Understood.
Mr. Hinsman, well, Your Honor, could I be put in a briefly in a breakout room with Mr. Hinsman to see what?
Hey, I'll pass this matter.
Okay.
State of Michigan versus Michael Hinsman, recall 23-00207.
Correctional Deputy for the People.
Robin McCoy for Mr. Hinsman. Your Honor, I did have the opportunity to confer with my client and get clarity about this. What he is wanting to have this evidence admitted for is the fact that he's asserting that she was drunk at the time of the accident. He is saying he doesn't recall whether she had any injuries at that time. So it's, we're talking about this. He's talking about a pattern of her getting drunk and then there being reckless behavior thereafter. He's saying at the time of the incident in question, where she's alleging he assaulted her, that she was intoxicated, and that she was intoxicated on February 3rd, February 7th. So, but he's not asserting that he saw or recalling any injuries to her person at that time. So we're not seeking it for that purpose.
Ms. McDuffie?
Well, Your Honor, I mean, that also presents a problem.
Yeah.
At least that there was some sort of relevance, if no nexus, but some sort of relevance to the case with regard to where her injuries might have come from as an alternative explanation for defendant being the cause of it. I was going to similarly object to the next allegation on February 3rd. I know we're not there yet, but that's the same exact issue, which is just the generalized complaint that she was drunk on a certain day. I don't know to what extent defendant should be able to just get up and those are character accusations as far as I can see, because the pattern of reckless behavior that he's describing is him just being able to say she was always drunk and she was always acting this way, and therefore we should look at her as a certain type
Attorney
of person,
Clark,
which doesn't really
right
have
this.
any, I think, relation or relevance to the charges here.
Ma'am, are you a whore? I object to the relevance of that, Your Honor.
Let's just get to the point.
All
right. What?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
So it's I would have the same sort of objection essentially, with the reason changing for her injuries to just her generalized character.
And Your Honor, if I may respond, the distinction for February 3rd is that on February 3rd.
I don't think we are. I'm not dealing with February 3rd yet. So
Okay.
I'm just dealing with January 25th. So as to January 25th, the reason that you're asking to use this is not a proper purpose under 404B. In fact, it's the opposite. You cannot use character evidence to prove this for the defendant, nor can you use it for the witnesses. So as to January 25th, that is denied.
Okay.
All right. As to February 3rd.
Did you want me to, or
no? It's the prosecution if she has any more to say on that.
Okay.
Nothing else regarding January 25th. I don't believe Ms. McCoy has started on. Oh, she did. I'm sorry. She did list them all out. So I would have similar objection to the third. The allegation was that complainant Lucas entered his home reeking of alcohol. That's pretty much the extent of what was there. I guess participated or initiated some sort of altercation. But again, I have no information as to what that incident is, if it actually occurred. I understand the defendant can make the claim. He could make the claims all day, and it goes to the same issue we just addressed on January 25th, which is his allegations that she's a person who drinks and exhibits behavior that's objectionable to him. So I don't see
Well,
where, yes.
Ms. McDuffie, I see that a little different. What they're arguing here is that because he was with this other woman, she told him that he could not, if he continued to see this other woman, he would not be permitted to see his kids. They are indicating that that is the motive to lie about this entire situation. This entire situation that we're before this court is a made-up lie to prevent him from being able to see his children. That is what the allegation is, and this is the beginning of that particular motive. So that's
Yes,
the distinction.
but there's no dispute that he was in that relationship with that other woman and that Ms. Lucas objected to it. But this specific date on February 3rd is about him being able to say that she was a drinker. So I don't, because it's not in dispute that this relationship was something objectionable to the victim and she didn't like it, that's not something that would need to be, Miss Lucas herself, for example, again, we're not on that yet. The other incident on the 7th is not, everybody admits that that happened. So it's very clear and understood, and I think and agreed upon by all parties, that there was a third relationship happening and Miss Lucas didn't like it. So to bring up this specific date on February 3rd to say on this date, she came to my house, she was drunk, she was reeking of alcohol. And as defense stated, I think in the motion, that this was another example of her reckless behavior. That is the problem, because it's not necessary. It doesn't show anything other than character beyond what we already have agreed to, which is that Miss Lucas didn't like that relationship.
See, I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Your Honor, our response is there is a distinction because as the court indicated, I mean, she says to him, and in Rachel's presence, as long as you can see Rachel, you will not be able to see the boys. And this goes directly to the motive to lie. Yes, there is the issue of her being drunk at the time that she's doing this and coming in his home and catching him with Rachel. But this goes to the 404B, the issue about her motive to lie about what happened on the 25th. She says it on the 3rd, and I know we're going to get to the 11th. She texted to him specifically. She said, as long as you see Rachel, you will not be able to see the boys. And then she alleges that he assaulted her. They get into an argument on the 25th about some of her behavior with leaving the boys at home alone. And then she claims the next day that he assaulted her. So this February 3rd, there is this issue about the motive to lie under 404B, and that's why we're requesting that it be admitted.
What does the alcohol have to do with the fact that she said to him that day that he wouldn't be allowed to see the children? Why? I mean, the reality is whether she was drinking or not is not relevant to that.
I think that what he is saying is he is asserting that on the 25th that she was drunk, and then they get into an argument, and then she claims that. So we're talking about, when we talk about the alcohol, we're talking about the issue about the admission under 406, the evidence of a habit of hers. She's got a habit of drinking and reckless behavior, lying, assaultive behavior, and then 405, reputational opinion, that she has it. So that's what we're saying, is that she catches him with Rachel. She barges in on them. She says she's upset about it. She's excitable. She says, as long as you see Rachel, you're not going to be able to see the boys. And he says that on the 25th, they got in, she was intoxicated. They got into an argument, and then she was aggressive towards him, and he pulls the gun to himself to prevent her from harming him. So when we're talking about the drinking, he basically is saying she is a liar and she is a drunk.
Exciting and new.
Part of our defense is that she has a drinking problem, and which he raises his concerns about his sons, about her leaving his sons at home alone while she's out drinking, and because she's upset that he confronts her about this, our position is she lied. She said that he assaulted her,
Oh, it's everything all at once.
and he says he didn't.
So on the February 25th, the allegation is she was also drinking on that date?
Correct.
All right, I will allow the fact that she came to the residence on February 3rd and that the verbal argument occurred. As to the alcohol, I'm going to take that on advisement. I need some additional, I need to look into some additional information regarding the drinking at the time. But I will allow the confrontation that occurred on that day.
Okay.
And the statement of how do you plan to get that in?
The February 3rd?
Correct.
We would, again,
Oh yeah, this is just a number 6.
we have our witnesses. We have him testifying and we have Rachel testifying.
Okay, thank you. All right. All right, as to the February 7th, Ms. McDuffie.
Your Honor, with respect to February 7th, this is an incident that was actually mentioned by the complaining witness in the police report. Obviously, they're going to have very different accounts of what exactly took place. Well, presumably they do. So I don't have an issue with the February 7th incident being mentioned in general, but I guess I just want to clarify. The court mentioned that you were going to allow the February 3rd incident with respect to her being there in an altercation. The mention of the potential injuries coming from February 3rd, is that part of that, or that's strictly February 7th?
There were no injuries. My understanding is that the crux of the February 3rd is that she said, as long as you see Rachel, you can't see the boys, and that she was intoxicated. But my understanding is there was no physical altercation on the 3rd. There was a physical altercation on the 7th.
Okay, I just wanted to confirm that. So as far as the 7th goes, I don't have an issue with the 7th because that is already an event that all parties acknowledge occurred in some shape. So
Thank you. So no objection, that will be allowed.
Okay, and then February 11th, we attached it as an exhibit A, where he gives a statement saying, "You told me
You already made your statement. It's the prosecutor's opportunity at this time.
Oh, okay, all right.
Thank you.
So
Ms.
February 11th, we have I'm sorry, I have way too many windows open and my computer is about to explode here. February 11th.
Well, the vibrator has to testify. I mean, it's seen things nobody else has.
Let me just grab that. Is that the email?
That's the text, exhibit A.
Message. Exhibit A.
Thank you. Okay. So this one here, I don't have an issue with it. My only question would be, well, not question, but this is going to apply, I think, to the email as well. The text messages here, obviously, it's a screenshot of one or two specific messages. So obviously, the door will be opened if the victim wanted to testify or object, not object, but essentially offer that there's additional conversation around that, because it's an isolated piece of a conversation. So we have, I don't have an issue with the message itself or the fact that she's alleged to have said those things, but it would also provide an opportunity for, I guess, rebuttal or some further questioning about what else may be there.
And that attorney is Darren Patterson.
And my response to that is, I mean, we provided what we are seeking to admit. We would just want to see what the prosecution is seeking to admit, so that we can give our response as to whether we agree to the admission of additional text messages.
I think that's fair.
I don't have anything sitting here that I'm saying that here's something specific that we have that we think objects or disagrees with that. Now, now that I know following this hearing that message is going to be in, I can certainly check with the victim and to inquire about it.
Yes, and it's his best client.
I'm just saying that in the same way that Mr. Hensman is going to be able to testify to communications that he had in person that we don't have any other reference for, that if the victim were to say, well, that's not all, she should be allowed to say that too. But I don't have anything specific that I know about at this point.
Thank you. The text messages from the February 11th will be allowed, and obviously if it brings up rebuttal issues, that will be explored to some degree. The court would request that if you do receive any text messages that need to be shared, please share those prior to the start of the trial.
Sure.
All right.
So next we have from the 11th to March 8th.
Correct.
March 8th is the PPO. I'm honestly not really sure how that even is an other act. It's not an incident. I guess the fact that she filed for a PPO, that was a little while after I believe this incident occurred. So I'm not really sure what it is that is intended to show or prove.
I think the argument is that that's a part of her scheme and plan to prevent him from seeing the children, Ms. McDuffie.
Well, the defense alleges that the PPO restricted defendant from having assaultive contact with her and from coming to her residence where the two boys reside. That's what was articulated in the actual motion. I'm reading from the motion and quoting it exactly. So if that is what was in effect from that doesn't show that, because assaultive contact would obviously be prohibited, and that specific residence being a place where he couldn't go doesn't prohibit him from seeing the children whatsoever. I understand there's other messages where she may say that, but this particular document does not, as far as that, let me just make sure I'm reading correctly. I don't believe this document precludes him from having, let's see here, any contact whatsoever with the children, including with like a third party. Is that what that does?
Well, Your Honor, may I respond? I don't think it's disputed that she filed a PPO after this incident, and basically the effect of the PPO was to, her argument probably will be she filed the PPO to keep him from coming there and physically harming her. Our argument is she filed it to keep him from being able to come to the residence and to see the boys. He's saying that after the February 25th incident that he didn't see the boys. He didn't see the boys again until we filed a motion on the family law case and to try to get parenting time. And so that's our position, is that she makes the false claim about him assaulting her, and she files a PPO. The claim about assault puts in place a no contact order. He can't have contact with her. And then she files a PPO saying he can't have contact. He can't come to the residence. It was months before he was able to actually see his boys. And even now, he only has restrictive access to his children since this incident.
If that's the claim, Your Honor, the document itself specifically excludes any restrictions about the children. Every single box is checked on Section 5 for what she's requesting that should be granted in terms of what he is prohibited from doing, except for removing the children from her. And so I don't think that it shows that at all. I think that if he had some difficulty seeing the children, it doesn't have anything to do with this document. I don't think this PPO does anything to make the point that defense is attempting to make. I don't have a problem with it coming in. I think it actually is more helpful to the victim to show that she felt the need to file it to protect herself from him. So I'm not objecting to the PPO itself as outside of 404B as just generalized evidence that would be admissible. But for this purpose, I don't think it's relevant at all.
And we do, in the
obviously you do. One moment, please.
Okay, I'm sorry.
So I think we all made our point. The reality is that once a PPO has been filed, if he had general access, which is what she argues in this particular document, to the children by going to the home, and he no longer does, whatever argument that she wants to make from that is the argument she gets to make regarding that. It does restrict his access when he had unrestricted access in before. Now, if you want to somehow present evidence, Ms. McDuffie, that she did not restrict his access, he could have had access to a third party, that's on you. But otherwise, I think you're shifting the burden If there's a PPO where he no longer has access to his children, that's relevant in their theory of this case, which is this is all filed in order to prevent him from seeing his children. So I will allow it. All right. So May 1st.
The May 1st, or not incident, but the May 1st is an email that states that, well, there's an email conversation between Ms. Lucas and it looks like Mr. Hensman's father. The exhibit provided by defense shows part of the conversation. So the header to this email is apparently from a previous message that Ms. Lucas sent earlier that day. So it begins with, obviously highlighted, starred, underlined. Her response that he'll have to pick them up. Also, no contact with Michael at 10:51, response to 9:34. But you can see at the bottom of that there's a message that she sent to, I guess, initiate that conversation on that same morning earlier. So I would, at this point, I would request more. Rule of completeness essentially is the issue. There's a conversation here that's been cut off in the middle, and there's clearly something that preceded it. So for context, for everyone's understanding, and obviously for the jury, when it's revealing that there was more here, I would object to it unless and until we receive the conversation in its entirety.
And I would just say that I was just given this snippet of it. I mean, I can inquire to get the fuller conversation and submit that. This is what specifically was provided to me. So
As to this particular document, I'm going to say two things. One, I agree with the prosecution that there is a rule of completeness issue because there obviously was a start of the conversation there, and that needs to be included. Secondly, the format that this is currently in is in no way acceptable because there are stars beside the statement from Ms. Lucas, and there's underlining that was apparently not there. It needs to be in its original format in order for this to be admissible. So we need both the complete conversation as well as the unmodified version of the documentation. If we have both of those, I will allow it.
okay, so I just want to be clear. We need the original format of the email and the complete conversation. Is that right?
Correct.
Okay. Okay.
And the vibrator. Don't forget the
All right.
vibrator.
Now on to the prosecution's motion.
Do you want me to argue my response, or?
Well, I'm going to let Ms. McDuffie outline what she plans to use so the record can be complete, and then you can make your response.
Okay.
Yes, Your Honor. So I originally submitted our notice of intent to omit statements under MCL 768.27C. And I can actually address everything at once because it looks like defense's response reflects a misunderstanding of what exactly this is and how it functions. So I tried to address this issue. I think previously we were asked what exact statements we were seeking to omit, and that's literally not the way that this section works. I read a couple of sections from the police report as an example of the source of those statements, but MCL 768.27C is not intended to identify or limit testimony to any specific quotes or verbatim passages. So just so that defense understands, we are not seeking to admit, her entire statement to police in that format or any other way. That's not really what it is. This DV exception functions like any other hearsay exception would during trial. So if a witness's testimony, if an officer specifically in this situation were to say she said, and that generated a hearsay exception, then hearsay objection, pardon me, then the attorney is going to argue, which would be me, that the disputed statement is admissible under that exception. Just like it would work with excited utterance, present sense, impression,
Only allowed to
anything
talk with
else.
Mike.
As soon as that objection comes, then the support for that argument is from those criteria. Here is why it should be acceptable. This is the same thing. So it's not that a party is going to be trying to admit every single possible thing that could qualify, but rather when a relevant statement comes up during trial, the basis comes from that rule. The issue about the notice, and I've probably been making this more confusing than it is. no notice is required for this at all. I just tend to do it anyway as a courtesy. So what is required here is there's no formal written notice. Is the fact that, again, as the statute states, that the defense, I want to quote it correctly, but the defense has to be basically notified about the substance of what those statements would be. And so that is why generally it comes from the original police report discovery. So what you already have, if it were to come from some outside source. So if I had some extraneous police report from a whole other incident, maybe another act or something like that, that is what would trigger the notification that says, hey, just so you know, here's a police report that has some additional statements that we would be trying to get in. And that is what you need to be provided, obviously, within that time frame that's listed in the report. But that's still a matter of just providing the report itself. I just tend to do this in a formal notice format to cover all the bases and make sure that everybody's informed. But I think what's been happening is that it's causing confusion, and this section is being interpreted as something that it actually isn't. So this is a set of qualifications or criteria, just like every single other hearsay exception that will come up. So given that, I don't want.
Well, that's all I've got. That's all I've got. I don't know how this ends. Direct all complaints to Lokificent. Go over to Lokificent's lair. Give her a piece of your mind on one of her videos. I don't know what happened. I don't know what happened. All I know is this.
Love, exciting and new.
That's all I know. That's all I know. It's exciting and new. Come aboard. We're expecting you. The Love Goat. I usually try to follow along the legal arguments and whatever. They're getting into evidentiary issues and all this crap and some criminal case in Michigan. I couldn't even. Once I got the facts, Judge Washington was like so flat. She's like, I'm like, come on. What's her name? Iraine, wake up, honey. That's the best set of facts you're gonna get. Okay. Nobody really got hurt. I mean, I know we'll claim they did, but nobody really got hurt. we got a flying vibrator. It's good stuff. All right. Well, I don't know what happens. So I will get two sets of negative comments here. I'll get a bunch of pearl clutchers saying, "Well, this is just awful. Why are we discussing this?" To which I say, pound sand. It was a court hearing, and it was funny. And then I will get how come we don't have the entire story and the police reports and the video of the incident and the verdict and everything else? Well, I'll tell you why, because that's all I got. That's why. I'm going to address it all right now. And then summarily ignore the comments. That's how I'm going to handle this. But that was fun. A bunch of people told me that that was fun, and they were right. That got wilder than I expected. That, usually it gets worse. That got worse early and stayed low. Fantastic stuff. Thank you all for coming out late on a Sunday. I appreciate it. It's a school night and all that stuff. But I felt the urge to just get this one in, and I'm glad I did. Thanks for coming out. I will see you all soon.